Very good afternoon to one and all present here. I hope you all are safe and healthy. Today we have our session on the topic matrimonial disputes in the times of COVID-19, and we have our speaker, our guest, Mr. Lalit Ajmani, independent practitioner at Delhi High Court. So without wasting any time, I'll invite Lalit sir to continue with the session. Please, sir.
Thank you, Atin, for inviting me, and thank you all of you for for taking out time and giving such valuable time to this session. As we all know, that matrimonial dispute is not a matter of just one subject or probably of couple of subjects. It's basically plethora of various disputes, and of course, it gives rise to various legal litigations, which you need to see which one to be followed. So I just tell you what we are going to discuss in this entire session, and then we can start with. We'll be dealing with 5 to 6 major concepts, which probably every matrimonial dispute witnesses. For example, divorce, whether it's a mutual consent divorce or a challenging divorce. Thereafter, we'll be discussing about maintenance, and the same will be followed by domestic violence, dowry debts, or dowry allegations. And one new thing which is coming up these days, that is live-in relationships. And thereafter, we can also discuss the defamation and right to privacy in these matrimonial disputes. Now, to begin with, let me start with the basic thing, that is the core of the entire matrimonial dispute. Whenever you are confronted with any matrimonial allegation, or whenever you are referred for any matrimonial dispute, you need to first decide as to what is the nature and what is the demand of that particular person is. For example, if some lady comes to you and asks that she does not want a divorce, however, she wants to live separately, and at the same point of time, she also wants some maintenance from her husband for the children that they are taking care of. So you need to see what exactly is the demand of the parties. Moreover, for a divorce lawyer, it is also the responsibility to actually help out whenever it's possible to mediate and to come to a particular win-win and, of course, lose-lose situation. Reason being that in every matrimonial dispute and at every possible stage, all the courts try to mediate and to get the settlement. Even after 10 or 15 years pending in litigations, people actually end up in getting settlement. Because, for example, I have witnessed one client who has spent 15 years and she's still fighting those litigations. And she has filed almost about 15 to 20 litigations against her husband and laws. And till yet, I don't think so that she would be able to get the peace. And of course, it's very difficult for her to get the requisite maintenance that she's asking for. But at the same point of time, she has been asked and she has been referred to mediation, not only by the court, but also by the opposite parties' counsels and her own counsel. So you can see that the basic threshold and the basic just what you can get out of all the matrimonial dispute is nothing but the settlement. So first, not only at the first instance, but throughout the divorce, throughout the matrimonial dispute, whatever the case may be, whether it's a divorce case, whether it's a maintenance case, or whether it's a domestic violence case, you should not close the door for the settlement. Even at a particular point of time, your client is not agreeing. You just keep the doors open so that after 1 year or after a couple of years, when the litigation thrashes the confidence and thrashes the anger of the litigants, then they come to settle the matter. So you need to take all these things into consideration. Now, once you get to know about what kind of case is, for example, we take one by one. This client comes up and says that she wants to divorce her husband, and at the same point of time, she wants alimony along with the maintenance. Now, you first need to see that what is the what is the date of the marriage, because in divorce, we are strictly talking about Hindu Marriage Act. Hindu Marriage Act basically is largely being followed by various other personal laws. However, Muslim law is something which is quite strikingly different from what we practice under Hindu Marriage Act. And if the parties belong to, for example, if the parties will follow Christianity or Parsis or Sikhism, these all largely or very similarly follow the same thing. And in fact, the Sikhism come under Hindu Marriage Act itself. So apart from Muslim law, we are going to discuss, we are going to touch every other religion. However, the people who are following Muslim, those who are Muslim, they can still get the benefit out of the session through the DV Act, which we are going to discuss, and the maintenance proceedings, because those are secular in nature and those are equally relevant to the Muslim people also. Now, having said that, coming back to the issue of divorce, now you need to see whether what is the date of the divorce, because the requisites which are mentioned in section 13 of the divorce act, read with section 14, it says that 1 year must be passed before presenting the petition to the court. Meaning, thereby, if the parties have, if the parties got married on 1st of January 2020, then you cannot file a divorce petition before before the end of 2020 only. So it means 1 year must be elapsed after the date of marriage. That is the prerequisite. And second thing, you need to see whether only your client is going to divorce or whether both the parties are agree. So in the concept of divorce, there are two kinds. First is the divorce where only one party alleges and the other party does not want to get divorced. And on the other hand, both the parties come together and say that they are agreeing for the divorce and they would like to move ahead with their own lives. So in the first instance, I give you the example, give you the prerequisite that the 1 year must be elapsed. Whereas in the concept of a mutual divorce where both the parties agree to get divorced, the requisites are that both the parties must be living separately at least for 1 year or more than 1 year preceding the date of filing of the joint petition. Meaning, thereby, for example, if the petition is filed on 1st of January 2021, so the parties must be living separately at least from 1st of January 2020. Now, living separately does not mean that the parties should be living separately physically. They can be living together under a same roof, but they must not be living as husband and wife. It means they have not been sharing the relation, and due to some economic issue or due to some family issues, they are not physically living separately. So this is the catch that we need to consider. And important point is that in mutual divorce proceedings, what happened that on the first motion, on the first date, the first motion is passed, meaning thereby that not it is not the case when the parties will go before the court and court will award the maintenance, court will award the divorce. No, it does not happen. At least two hearings are required. First is the case when the parties will go, they will receive the first motion, and the similar strategy needs to be followed after 6 months, after 6 months following the grant of the first motion. Meaning thereby, for example, that in the case on 1st of January 2021 they filed the case, and on the 1st of January itself they got the first motion divorce. So they have to wait for another 6 months to file for the second motion of mutual consent, and only after receiving the second motion they are legally called as distinct and their marriage is dissolved, not before receiving the second motion. And it quite happens that after the first motion, either of the parties takes back his or her consent and says that he does not want to proceed with the divorce proceedings. So all in all, in that scenario, we come back to the situation one, that is only where one party wants to settle the matter. It quite happens. Reason being, for of course, for due to emotional trauma, or when people are seeing that they are not going to see each other throughout the life, then probably the importance comes up. And second thing is that it's a delaying tactics being followed by the parties. For example, they know that they probably need to wait, the other party needs to wait for 6 months. So first they agree for the divorce, and then at the last time they say that they are not willing to get the divorce. So it quite happens. Now, in certain scenarios, court have the right to limit the cut down the period of 6 months. And in few cases, we have seen that only after 1 month or only after a couple of months, people get the second motion also. Now, the prerequisite of getting this cut period is that the parties must be living separately at least 18 months prior to the filing of the first motion. Now, we took the example that the parties must be living separately from 1st January 2020. But if they want or if they want to explore the opportunity of getting the second motion, even prior to the 6 month cooling off period, which I just mentioned, then the separation period must be of 18 months preceding the date of filing of the first motion. And of course, this is not the only criteria which the court see. The court will also see that there is no point and there are no chances that the people, that husband and wife, are not going to stay together. So these two, three things which we need to consider at the time of filing second motion. And at the same point of time, a few practical things which we need to consider, that while filing the mutual consent divorce, a settlement agreement needs to be drawn up where all the issues of maintenance, domestic violence, or pending litigations, if any, they must describe everything. And generally, it is seen that the husband pays certain amount to the opposite party for the maintenance or for the expenses which her parents have spent during the maintenance proceedings. So at times people don't. There are few cases where wife comes up and say that they don't want any kind of money or any kind of maintenance from the other party. So you need to clearly mention that it is of free will, that the wives are not willing to take even the penny. However, it's always advisable to mention some reasonable amount regarding the lifestyle being maintained by both the parties, because then it's conveniently easier for the courts to drawn up and to grant the motions of divorce. Now, this is basically the gist of the mutual divorce. Now, coming back to the case of challenging divorce, in the means that only one party wants to divorce and the other party does not want to get it done. Now, before I move ahead, I request everyone, if you have any questions, please kindly put it in the chat, so that suppose if I complete this divorce proceedings and when I move ahead with maintenance, if one or couple of important questions regarding the divorce are coming up, so you may keep mentioning in the chat box. However, the last 15 or 20 minutes are specifically reserved for Q&A session. But I think that we can also address one or couple of questions to make it more interesting, as well as I can get to know as to what the audience is looking for, and with respect to that I can move ahead. So whenever Mr. Ratan, when I complete this divorce, you may just surprise me one or couple of questions which are most relevant, and of course
Sure,
every question might not be addressed at this time.
sure, sir, sure.
Now, thank you. Now coming back to the divorce, as I said that in this is the most litigious part of the divorce of the matrimonial proceedings, that one party wants to get divorce and the other party does not. Now in this case, the most important part is the divorce petition, which needs to be drafted by the claimant. Now the divorce petition, I would say that this is the most trickiest part for the lawyers. Even for the arbitration, or even in the commercial arbitration, commercial cases or arbitration proceedings or any company proceedings, the drafting is quite, I would say, simpler, because you know everything and it's always upon the records. But in when you draft a divorce petition, you probably have nothing to prove, because all the things happen within the confined walls of the home. So you need to be very smart, and you need to know what kind of things you need to mention. For example, in drafting, what people have exaggerated or what people have stated, mainly due to the complaints or mainly due to the allegations put forth by the client. But you need to draw what can easily be presumed. For example, if there are so many glaring examples of grave abuse, then rather than mentioning everything, it's better that you mention a few of those instances, coupled up with drafted in such a manner so that it would presented in such a manner that the court will be more inclined to assume that whatever you have stated is actually believable, and the court right from the day one has this tendency that whatever this petitioner has come up with, she or he is actually being thrashed or is actually being abused by the other party, and therefore the petitioner must be granted divorce. The divorce petition, as I said, that it's tricky, of course, and it's a lengthy draft also. So this is the most important thing. All the law students, lawyers, or perhaps people who don't belong to legal background, make sure that whenever you are drafting this divorce petition, you must give your attention towards this drafting, because once it's drafted and submitted to the court, you have to follow, and your case will be based upon that petition only, even till the Supreme Court. For example, if you go in appeal, so the divorce petition must be drafted, and the equal amount of effort must be put in by the client also. And suppose it's difficult for most of the clients to recall every kind of activity that may allow them to seek divorce. So it is the responsibility of a lawyer to make him or her aware and make the consultation so conducive that he or she can recall, or you can assist them. So for drafting, I'm asking you again and again, this is the most important part, and I think that it's as I said, that it is one of the trickiest it is one of the trickiest petitions to draft. Now, having said that, what are the things that you need to mention, and what are the criteria which entitle a person to get divorced? First is, of course, that the extramarital affair by either of the parties. The second thing is that the other party has, has left the company of the spouse. Now, the desertion must be of couple of years. As we have stated, that at least 1 year must be preceded from the date of filing of the petition. But if the divorce is based upon the desertion, meaning thereby that one party has left away the company of your client, then 2 years must be elapsed for the desertion. And one of the interesting causes for divorce is that the other party has renounced from the word, or perhaps has changed his religion. Now, even when the other party has changed his religion, that's a sufficient ground for the divorce. And lastly, I would say that the most common ground is the cruelty. Cruelty meaning thereby that any kind of pressure, continuous pressure. It's not just every kind of tussle or everyday fight can come up with, but what shakes the basic structure and the sanctity of the marriage, then that will amount to pressure, and in legal terms we call it as cruelty. So the cruelty has various connotations. It could be on economic basis, it could be on emotional basis, and of course it could be on physical abuse also. So if a party is continuously abusing his wife physically or emotionally, or not giving maintenance, these are the sufficient grounds to these are sufficient grounds to attract divorce. Now, I have just stated that all these things are confined within the walls, so you have to put it in such a manner that when you draft it, it becomes believable. And of course, you don't have proof either to verify or either to disprove the allegations. What you can do, that you can take your in-laws, your family, as well as the neighbors. Rather than friends, I would say the neighbors, because whenever there are grave issues, or whenever there is a physical abuse or any abuse which shakes the sanctity of the marriage, the neighbors are the first person who get involved. So at the time of filing of the petition, you get the confidence of all these people that tomorrow there might be a possibility that they need to come and testify on their behalf. So you may add example of one of the neighbors or one of the incidents where the third party has turned up and witnessed all this thing, or has saved either of the parties. So these are the few things that you need to take care of. And moving forward, that where you can file. If the wife is going to file, wife can file where she is residing. or where her husband is residing, or where the marriage took place. Whereas if the husband is filing the divorce petition, then he has only a couple of options, where the wife is residing or where the marriage took place. So this is one additional benefit being provided to the wife in such cases. Now, at the time of marriage, one important thing that comes up, that is the maintenance. For example, if on the one hand the wife is constantly abused on the basis of economic disparity, or where she is not getting even the basic amount to take care of her needs and wants, then how can she afford a good lawyer? So for that, you can file an application under Section 23 of Hindu Marriage Act, stating that a person or a wife who is unable to maintain herself, he or she can ask the requisite amount from the other party, of course, through the directions of the court. Now, the interesting part is that the Section 24 of Hindu Marriage Act is basically gender neutral. Otherwise, in all maintenance proceedings, as we will be discussing in the later part of this session, the maintenance is provided only to the woman. But in Hindu Marriage Act, even the husband can ask for maintenance, because as now it's not uncommon that the wives are earning much more than husband, and husband, due to one issue or the other, are being dependent upon the wife. So if the husband who has filed the case for divorce, and he can prove that he is unable to maintain himself, whereas his wife is uh, uh, you know earning a lot of money, then the court, considering the facts of the case, can ask the wife to pay certain amount of money to the husband during the divorce proceedings. So this is the peculiar aspect regarding the divorce. Now, coming, I think that I have given a glimpse of the divorce. If there are one or couple of issues, Mr. Ratan, that I should address regarding the divorce.
Deshri, would you like to have three questions?
Yeah. One or couple of questions. I have seen 10 or 12 texts. One or two questions, whatever you think that probably more.
Sure, sir. In section 13.2, my screen has gone. Then my questions are gone. Can you please read it out for now?
All
Sorry.
right. So I'm reading. Just a minute, please.
Okay.
As you have mentioned about matrimonial disputes, there is one more thing that arises for disputes. That is about the marital rape. What should we do regarding this?
As we have discussed, that the physical abuse also attracts the form of cruelty, and therefore the divorce proceedings are maintainable for the same. However, the uh, aspect of proving it, it's very difficult, because in such scenarios it's but obvious that the woman is being deprived and is being thrashed on a continuous basis. And if the woman or if the girl is coming up after a lot of time, then it's very difficult to prove the same. However, what we can do that, when such scenarios comes up, we ask to file the police complaint, and then from there on we need to draft our petition accordingly. And of course, we can ask, we can allege that the physical abuse took place, and therefore the cruelty must comes into picture for the grant of divorce. But as such, the matrimonial rape, as we all know, is not being recognized by the Indian legislature as of.
If a man has two wives or has one wife and one mistress, then what will be the consequence of cruelty by one wife over the other?
One wife over the other. There is, I would say, disparity in the question itself, because in the first instance, I'm getting to know that there are two wives, and probably on the other, I'm getting to know that there is one wife and one mistress. So first, I need clarity if there are two wives, or if there is one wife, or and there is one mistress. Oh, okay. I think it's taking time. I can discuss the both. Now, suppose there are two wives, And if the marriage took place after the enactment of the Hindu Marriage Act, that is 1955, if after if after 1955 the person got married with the second wife, then the second marriage is void ab initio, meaning thereby that it is not marriage at all. So the acts related to the second party or the wife, the second alleged wife, does not have any legal right, even qua the husband or qua her first wife. Whereas first wife can initiate action against the husband for having extramarital affair and for fraudulent purpose also. And what we are saying that the conduct of the second alleged wife over the other over the first one can ask for the divorce, stating that the husband, in collusion with his alleged second wife, have committed gross cruelty, and due to the same, the entire sanctity of the marriage is now being under question. So therefore, it doesn't make any sense to stay in these divorce ties, no, in this matrimonial ties.
So we can proceed with our
Yeah, we
next
can
topic
proceed.
now.
Yes. And just one more thing regarding the divorce. For example, there are certain cases that where the fraud has come into picture just after the marriage. For example, in one of the cases which I have just handled, the boy comes to me and told me that the wife is not ready to maintain any kind of relation with him. Reason being that she was pressurized by her parents and she is in love with somebody else. So just after the marriage night, he got to know about it, and right from the marriage, they are living separately. So it's a cruel case of fraud, and in such cases where the question and where the free will of the parties are in question, or where the fraud is being committed upon the other person, even then in such cases, the petition can be filed even before the expiry of 1 year. Now, in such scenarios, you do not seek the divorce, but you just seek the dissolution of the marriage. So, in any case, the marriage is going to be dissolved either by divorce or either by the other proceedings. So, this is the exception of waiting for at least one year period. Now, moving ahead, that we have already discussed divorce. Now, coming with the second important issue, that is the maintenance. Now, as we have discussed in the first part, that in certain scenarios, people do not want divorce, but they want maintenance, and maintenance mostly generally being asked by the woman only. For that, you have various options. For example, that if divorce proceedings are already pending, you can go ahead and file the application under Section 24. Suppose if the divorce proceedings are out of picture and she does not want to go ahead with divorce, then you can go ahead and file Section 125 petition, Section 125 of CRPC. Now, this is general neutral law. Even a Muslim woman or any woman who follows any kind of religion can follow and can file petition under Section 125. Thereafter, she also has one more remedy, one more procedure to comply with to get the maintenance. That is the domestic violence Section 23. We'll be discussing about the same in detail when we'll be discussing about cruelty. However, there is one application which we can file over there also. Now, in Section 125, it's relatively easier, and not lot of things needs to be done. Unlikely, as we have already as we discussed in the divorce proceedings, that the divorce petitions needs to be drafted with lot of care. But in maintenance proceedings, of course, you need to be diligent. But it's relatively easier because it's a petition of only 4 or 5 pages, where you just need to mention the facts as to when the people got married, and why and how the other party is torturing the petitioner, and what is the amount that they are seeking, and if there are children, then who is sponsoring the children, and who is in the children is the custody of whom. So all these necessary facts, basically the summary of the entire factual proceeding, need to be mentioned in that petition, and that needs to be presented with the court. Now, the court has 2 or 3 things for this 125 petition. The first thing is that during the proceeding itself, the court can award interim maintenance to the other party, meaning thereby that as we all know that the cases take 1 year, couple of years, or more than 2-3 years, even for such small proceedings. So during the pendency of the case, the magistrate will ask the opposite party to pay the interim maintenance, and the same will be adjusted at the time of final judgment. So that's the first thing. Now, second thing is the income affidavit of both the parties. Now, in maintenance proceedings, both the parties need to file the income affidavit. Income affidavit is basically very long, and it basically covers almost everything as to what is your income, what are your expenses, and what property do you have, whether you are sponsoring this litigation through your own means or through the means of somebody else, and what is the litigation expense also, and what shares you have, and all the necessary financial issues are being asked in that affidavit. It's the affidavit in Delhi. We follow the guidelines of Kusum Sharma case, where the detailed affidavit is being provided, which needs to be followed by both the parties. And after considering the affidavit may be annexed with certain documents to prove whatever the parties are saying. Now, in most of the cases, people don't come up with the actual data, especially the respondent side. The husband does not come up with the actual data, and if he is doing some business, then it's a cakewalk for him to hide the facts. So it's actually very difficult for the wife to prove everything. So what she can do in such scenarios, that if she has proof regarding the lifestyle that she was cherishing it with when the parties were living together as husband and wife, then of course those evidences can be brought up and assess the court to determine the actual income of the husband. And of course, at the same point of time, you can ask your parents or your neighbors to come up in the witness box and testify on your behalf. So this is one simple way of getting maintenance. But as I said, that it takes 2-3 years easily, even for such small proceedings. Now, the second way of getting maintenance is that you may file an application under DV Act, that is a Domestic Violence Act. Again, this proceedings can be initiated only by women. Men are being deprived of asking maintenance. I'm not saying that it should, the men should be granted with such rights or not. I'm just saying whatever the law is saying. So the men are generally deprived of asking all these maintenance, apart from Section 24 under Hindu Marriage Act that we have already discussed. Now, in Domestic Violence Act, two important issues are there. First, the woman can come up and say that she is entitled for the compensation for all the abuse and for the economic abuse also, and thereafter a lump sum award can be provided to her. Now, the second part is the interim application, as we have already discussed in those two issues, that the interim application is also there. So during the domestic violence case, Section 23 of the DV Act is the appropriate section under which the application can be filed seeking interim maintenance. Now, coming back to the first part, that is what's the nature and what's the demand of your client. Now, we have discussed divorce, we have discussed maintenance. Now, the third point is the domestic violence. For example, if your client is saying that she is being abused, not only by husband, but also by her in-laws. And it is basically the conspiracy, mostly almost on daily basis or regular basis, that she is facing up, and she needs compensation, or she needs something, or she basically needs some kind of punishment against the husband as well as the in-laws. Now, this is the special legislation which gives the right to the woman not only to ask compensation against from her husband, but she can also array her in-laws to be as parties in that particular case, and state that whatever cruelty is being inflicted upon her, it's not only the husband, it's also the equal, it's also of equal contribution by her in-laws. So this is not available in maintenance. This is not available in divorce proceedings. It is available in DV Act, and it's available in a dowry case, which we'll be discussing in the upcoming part. Now, in DV Act, what we can do, what we have to do, again, we need to prepare the draft in two separate forms. First is what is already being given in the schedule of DV Act. Basically, there is a chart stating that what a person is asking for. For example, if she is asking for maintenance, if she is asking for separate residence from her husband, which should be sponsored by her husband only, or whether she is asking for any kind of medical expenses or economic expenses or the expenses for her children. So all these columns needs to be taken care of, and thereafter the facts of the case can be provided. Now the facts of the case is basically the entire petition and entire output of the lawyer. Once again, as I stated in the divorce petition, that the petition in the divorce is a tricky one, and you need to be very, I would say, not just clever, but also being aware about what the court is ready to believe upon. Uh, it quite happens that the drafting style and the presentation style differs from one court to other court, only to present your case or to make your case more believable. As in one of the Delhi district court, there are two family courts. One follows the liberal approach, and the other follows a bit strict approach. So you need to make sure, as to suppose if X judge or Y judge or any judge is coming, so you need to present your case accordingly. It's not a straitjacket formula that you can go ahead with the beginning till the end. So it's basically the art. Of course, the practice will teach us a lot regarding how to present it. But why I'm focusing upon the presentation, because as we discussed, and as we now know, that it's almost impossible to prove anything for sure regarding the matrimonial dispute. So it is only the story that we come up with and the additional evidences that we are providing, because the other party can also come up and he can also ask his good neighbors or family members to come up and testify in his own behalf. So basically, both the parties have nothing to prove or disprove. So that's why everything comes down to your story that you draft and the presentation along with the evidences of both the parties. Now, in the set of facts, when you present the case to the concerned magistrate, you need to also ask for the requisite maintenance right from day one, because it's always advisable to come up to send this application on the day one, because when the other party comes up, he will take one or couple of dates of hearing, and that will take another 6 to 8 months. So considering or thinking from the on the feet of your client, he or she needs to wait for 8 months to receive the order of getting a single penny from the other party. Forget about the real execution of that order. So for limiting and for making the work easier for your client, it's better to file Section 23 application at the first instance only. Now, what court will do, court does not go ahead and direct the other party to come up. The court will appoint the special officer to conduct the inquiry. The special officer is being termed as protection officer in DV Act. Protection officer basically checks the veracity of the allegations that you put in, and she basically states that whatever you stated prima facie, this is believable, and the court should take the cognizance of the same. And after considering the report read with your complaint, the court takes cognizance and asks the other party and sends the notice to the other party to come up and present his defense. So this is how the DV proceedings, are conducted. And now the fourth important topic is the dowry. It's dowry is basically covered having two issues: dowry debt and the dowry abuse. Now, for example, again coming back to the first session, when your client comes up and says that she is being harassed solely for dowry, and she needs nothing but the action against the husband as well as in-laws regarding the dowry, and she needs nothing else. At times it happens because people in such scenarios are being are being driven by the emotions primarily. So they just need a kind of justice rather than asking for certain for any kind of compensation. So in such scenarios, what you have to do, you need to draft a police complaint. Police complaint stating every possible or every important details regarding the dowry allegations, and you present it to the CAW cell of the concerned police station. Now, CAW cell will take the cognizance of the complaint. The cell will ask the husband and in-laws. Now, in dowry proceedings, you can also array the in-laws, as you can say that your in-laws are also asking and also pressurizing for dowry. And one thing I clarify before we move forward, it's not the case that only the first few years are the only relevant years when you can file for the dowry application. It's not like that. You can come up after 10 years, 20 years and say that after 15 or 20 years, your husband or the in-laws are asking or are pressurizing for the dowry. So it's perfectly legal. But at the same point of time, you have to draft it in such a manner so that it would actually convince the authorities as well as the judge to consider your allegations. Now, when the CAW cell asks the opposite parties to come up, they don't straight away register the case. They ask the parties to settle, and sometimes they take 2, 3, 4 mediation rounds before deciding whether the case should be proceeded for registering of FIR or not. This is very cumbersome because, as you can imagine, that the wife is already suffering from the torture of the opposite parties, and once again, when she is going with the before the police is asking to mediate and to settle the matter with the same people. So it's actually very gruesome for the women, and at the same point of time, it's time taking because it generally takes 3, 4, and at times 6 months also when the parties are living separately, especially in different states. So it's actually difficult for the CAW cell also to comply with everything within a week or within 2 months, within a month or so. And after the settlement proceedings, when the CAW cell is absolutely sure that there is no possibility of settlement among the parties, then on the basis of the complaint which was filed by the complainant, they register the FIR, and the police, on the basis of FIR, conducts the investigation. And after the investigation, they file the charge sheet before the concerned magistrate under section 498A generally. And if there are other related sections also, for example, that there is a breach of trust or there is harassment, then those things can also be put in. So it takes a lot of time to witness or to get the case registered with the concerned magistrate or with the concerned court. It takes somewhere around 1 year. So you need to make sure, and you need to apprise your client that it may take some time. And at the same point of time, it's much better to initiate as early as possible, because the complaint which you have given for dowry related issues, the same complaint will be used in other proceedings. And if your client is not sure that she will go ahead with the other proceedings, but rest assured the other party will definitely come up and file some counter cases, and he will definitely use that complaint against you. So it's always advisable that if you see that there are no chances of settlement, that you first begin with this complaint, and at this simultaneously you if the demands are related to divorce, maintenance and other things, of course you can go ahead with those things also. So that's basically the beginning of all these 4 litigations. That is the divorce, second is maintenance, third is your DV, that is the violence, and the fourth is dowry. So these 4 main issues are being touched upon, and the fifth, which we are going to discuss, is the custody. It's still common, but but relatively, it's being dealt in either of the proceedings that we have already dealt with. But at times it's seen that the people are living separately, but the children are in the custody of only one person. But the other person wants the custody of her or his children without seeking any maintenance, divorce, or anything else. So for that, you can file the custody application before the concerned court, and stating that you first you need to mention that why you are competent and how you are competent enough to take care of your child. And at the same point of time, you also need to mention that the other party is not self-sufficient and probably is not a good guardian to take care of the children. So it's a two-way process which keeps going on. And generally what happens that as we discussed earlier, that everything is being discussed or everything is being dealt uh, with the view to settle the matters. So when the children come into picture, then the matter becomes more delicate, because it's not the fight between the two people, it's actually the welfare of the children which drive the decision of the judge. So generally, in the beginning or during the pendency of the case, court asks for the visitation rights. Court may ask if the children are of 14, 15 or more than of that age. For example, if judge sees that the child can be asked. So at times, judge in the chambers ask the children and try to ascertain whether who is the better parent to take care of. Of course, it's a difficult task. There cannot be a any straight jacket formula, and of course, it depends upon the discretion as well as the approach of the concerned court also. Because at times the court do not take the say of the children, because stating that they are of course minor and they cannot decide, and it's probably not good to child to come up and say what he or she wants to who is the concerned person to with whom he or she would like to reside. As generally people see that the children should be stay away from the courts and all the legal proceedings. For the people, for the children, of course, till the age of 11, 12 years, it does make sense. But after 12 years, I think that the judge must consider the the say of the children, because nowadays children having age of 12, 13, 14, they generally know what's going on, and it's very difficult even to fool them by either of the parties. And of course, the few important things which drive the decision of the court is that first, the economic status of the parties. Second, the pendency of the other litigation, if the litigations are already pending. And third, where the children are studying. And as we discussed earlier, that if there is a chamber proceedings, then what the children are looking for. And lastly, if there are any allegations or if there are any proof regarding the character of either of the husband or either of the wife, then this also drives the decision of the court regarding the custody. As recently in the case of Deepti versus Jatin Saluja, decided by Delhi High Court on 30th of June 2020. It's just 2 weeks before. In this case, the court was confronted with the issue that the evidence obtained by the husband by breaching the privacy of wife, whether that particular evidence can be used or not. So in that case, the husband has illegally got the tapping of the wife's phone, and she was talking with her with some of her friends, and she was saying some bad things about the husband. So that particular conversation, whether that conversation can be used in a court or not, because that of course infringes the right to privacy. So the court took the liberal view and stated that it is basically upon the discretion of the family court, and at the same point of time, court cannot disregard such evidence merely on the basis that it is being obtained through illegal means or it has breached the right to privacy of the other party. Now the point I think that it may encourage various litigants to gather evidence through such ways, especially in the cases of custody, when because for children people actually are ready to cross the lines. So in order to testify or in order to prove that the other party does not hold a good character, then in certain scenarios such evidence may prove detrimental or may prove very crucial to either prove the case or to disprove the other's case. So I think that that's one of the judgments which we must take care of for all matrimonial proceedings. And of course, having said that, the judgment also clarified that merely that the evidence is accepted in a court of law does not mean that the husband cannot be sued for such illegal means, and the wife can initiate civil or criminal proceedings regarding her rights. But all in all, those evidences can be produced not only in divorce proceedings, but in but in other matrimonial proceedings, like in custody or maintenance or anything else. So this is basically the structure of five things that we have just discussed. And just last thing before we move forward, for example, if there is no custodial case separately, but at the same point of time during the divorce proceeding, the custody is being considered, the normal application can be filed before the concerned court and asking for the custody. And court, it is the prerogative, and of course, it is the duty of the court to consider the welfare of the child and to decide during that time only that where as to whom the custody can be awarded with, and who is basically the better person to take care of the children. Now, lastly, I think that there is one important aspect which is, touching the touching the interest or touching the needs of today's generation, and not just today's generation. Probably the issue which is being followed these days, that is the live-in relationship. Uh, Mostly, generally, we know that probably people are in 20s or 30s live in follow this live-in relationship. But you will be astonished to know that people who are living in 50s or 60s, they are also living in they are also having living a relationship. Like in just one of the examples, one of the questions which we have discussed, that the one person has having marital obligations or marital ties with one wife, but at the same point of time he is also living separately, and is also living with some other girl. So the other girl, the relation of that couple will be termed as live-in relation, can be termed as live-in relationship. So in such scenarios, what are the rights available to the parties? So generally, courts consider one important aspect, and that is whether the parties are living together for a certain point of time. It should not be the case that the people are living just for one day or couple of days. And second thing, whether they are being construed as husband and wife by in the eyes of society or not. For example, that if the people if there are roommates and they are just living as roommates, and the society knows that they probably are just roommates and not having any relation, and it's just probably due to PG arrangement or some rental arrangement, then probably the people cannot, the parties cannot allege that they should be receiving any rights, because from in the eyes of the society it's just a temporarily rental arrangement which both the parties are coping up with. But on the other hand, if the parties, if the people, and especially in the society, they are acting as and husband and wife, they are meeting their friends, they are in social scope, they are living as husband and wife, and they are being reciprocal not only on economical basis but also on emotional basis. Then in such scenarios, almost the same rights which are being provided to the husband and wife under the matrimonial laws, which we have already discussed, the same rights are also available to the concerned wife, to the concerned girl, and to the concerned boy. Now, for example, the the girl can ask. It's a bit tricky, but of course she can file the application for seeking maintenance. And on this second issue, that the violence, the domestic violence, of course, that is there. The girl can ask for domestic violence also, and other related issues. If suppose if there are children born out of that cohabitation or the living arrangement, then if there, of course, there if there is an issue of who has the custody, then the same laws will be prevailed, considering that considering those people as husband and wife, and in the light of the same, that the people living in a living relationship have the similar rights which the normal husband and wife possess. And before I invite Q&A session, I think one important part which we can also discuss is the defamation thing. For example, in certain in all the cases, a lot of hue and cry, and especially a lot of you know uh, unwanted words are being said by both the parties, and that's the same gives right for the defamation also. So the parties have the right to file defamation against each other, even despite being husband and wife. It does not matter. And for the criminal defamation, the time period is just 3 years. Whereas if the civil defamation is considered, civil defamation is provides you the time limit of 1 year. Meaning thereby, for example, if some defamation or if some derogatory remark was communicated in the presence of somebody on 1st of January 2020, then for criminal defamation proceedings, 3 years is the time limit for meaning thereby that the case must be filed within the 3 years after that 1st January 2020. But if you are seeking civil defamation, the same must be the same must be filed within 1 year from the date of the derogatory remarks publication. Now, in criminal defamation, you basically seek for punishment, whereas in civil defamation, you do not seek any punishment. You seek the basically the compensation from the other party, and based upon the life and based upon the lifestyle and based upon the goodwill, based upon the scenarios which has thrashed the goodwill of either of the parties, that could come that could be a considerable issue to decide the quantum of the civil defamation. And for civil defamation, one more important thing which we need to consider, that suppose if I file the civil defamation for 10 lakh rupees, I need to pay the court fee regarding 10 lakh rupees. Of course, it's not 10 lakh rupees. It depends upon state to state. Somewhere it's 2% of the 10 lakh rupees. Somewhere it's somewhat, for example, 4,000 or 5,000 when the case is of 10 lakh rupees. So that needs to be considered, because for in criminal defamation, such court fees are not being produced. And at the same point of time, lawyers should also be aware that the appropriate court fee must be filed, because a lot of cases are being turned around just because the requisite and the appropriate court fee is not affixed while filing the civil defamation. So I think it's good enough to ask for questions right now. We have all, I think, briefly discussed the main issues of matrimonial litigations. Is that okay, Mr. Ratan? We can take the questions. You can
Yes,
unmute.
sir. Now, if you want to ask the questions from sir, you can write your name in the chat box. We'll allow you to unmute and you can ask your questions directly from sir. Can you throw more light on marital rape? Pooja Reddy is asking.
Ms. Pooja, as we already discussed, first of all, there is no marital rape according to Indian laws. So the question is out of the picture that the marital rape actually exists. You can just state it that the physical abuse took place. Of course, you could take the criminal action simultaneously, and once you mention that the concerned act, the marital rape took place, you need to mention in the petition. And of course, as we discussed earlier, that you need to mention in such a manner that probably other connected incidents are also presented in such a manner that your case should come up with. And at the same point of time, you must also file criminal case. You must also file police complaints. And if the police are not taking action against that, then you can go ahead under section 156, asking the magistrate to direct the police authorities to register the FIR. So these 2-3 things that you must do while dealing with such questions.
So I think everyone wants we read out the questions to you. No one is willing to ask on their own. So yeah. So what is meant by the cost of the plaint? How it's calculated?
It's basically cost of the plaint are calculated on 2 bases. First, that is ad valorem, and second is that's a fixed court fees. Ad valorem basically means that what it depends upon the claim that a person has asked for. For example, we took the example of 10 lakh civil defamation case. So in such scenarios, in defamation cases, the court fee is decided accordance with 10 lakh. And the court fees basically differ from state to state. In some cases, a requisite percentage or a particular percentage is provided. For example, in defamation cases, 2% of the entire claim amount needs to be paid along with filing the petition. But in some other states, the requisite percentage is not mentioned, whereas the usual practice which is being followed in that particular state needs to be considered. But at the same point of time, it generally revolves around 2 to 3%, uh, uh, taking some 5-10,000 here or there, but it generally happens in that. And the second part is that the fixed court fee. Fixed court fee is basically when the legislature has put a certain amount of money, irrespective of the amount which is being claimed. For example, in divorce petitions, in Delhi, you need to affix only 15 rupees. You don't need to mention, or you don't need to affix the court fee in regard to the maintenance amount that you have asked for. For example, if the family are millionaires, and of course one of the parties has asked for lakhs and lakhs of rupees as maintenance. So even for that, person does not need to pay the ad valorem court fee. Only the fixed court fee needs to be paid up with. So the Court Fees Act is the concerned statute which may enlighten you more on this aspect.
Miss Safa Fatima, you can unmute yourself and ask your question.
So can I ask question?
Yeah.
Please wait, Surya. Miss Safa.
Hello.
Miss Safa, am I audible? All right, Surya, you proceed with the question.
Good evening, well, sir. So my question is about will the maintenance be provided after the mutual divorce of the after marriage they divorce mutually? Will the maintenance will be provided to the woman?
See, generally in mutual divorce, as we discussed, that one settlement agreement is being drafted and is being provided to the court. So in that settlement agreement, everything is written. For example, if it is written that the husband shall be providing 10,000 per month on monthly basis till the time that the wife does not get remarried. So if the same is not followed, then of course you can file the application for the maintenance. But at the same point of time, if the settlement agreement says that a lump sum amount, that is, for example, 20 lakh rupees are provided to the wife, and after the mutual divorce, the wife cannot ask even for a single penny, then in that scenario you cannot ask for any maintenance.
Okay,
So,
thank you,
so,
sir.
so Safa is asking, how does protection of women can be achieved by incarceration of husband when the law declared it non-bailable offense?
Sorry, I didn't get you. Could you unmute her?
How does protection of women can be achieved? Can you see the question or like?
Yeah. Okay. How does the protection of the woman can be by incarceration when the law decided it non-billable offense? Can you read it for me? Okay. Protection of women can be achieved by incarceration when the law decided it non-billable offense. See, Ms. Safa, it depends upon facts to facts, that the incarceration of husband, of course, depends upon the facts of the case. And since it's a non-bailable offense, uh, before I just throw the light on this, one important thing that I probably skipped, that is these matrimonial cases can be proceeded simultaneously. For example, if one divorce proceeding is pending, at the same point of time, some criminal case can also be initiated. Maintenance proceedings can also be simultaneously proceeded with. So in such cases, of course, you will mention your issue in the divorce proceedings. At the same point of time, when such offences is not specifically covered up with the divorce or with the cruelty, then you can take the help and you can go ahead for and file the criminal action. And at the same point of time, you must ask for the DV also, DV proceedings also. So it basically depends upon the appreciation of evidence during the criminal trial rather than in the divorce proceedings, because divorce proceedings don't lead to the arrest of any person. So first, again, we go back to the base of the matrimonial issues. What your client is asking for. If she is asking for compensation, of course, then there is no need of going ahead with the criminal process. But if she is asking for the arrest, or if she is asking for a kind of justice, then the probably divorce or maintenance is not the requisite forum, because even if your case is being proved, then the court does not have power to arrest or to imprison the opposite party. For that, you need to avail the fundamental criminal remedies which are available in IPC.
Rachel, you can proceed with your question.
Okay.
Rachel?
Can I ask? Yes. Rachel,
So can you hear me?
Yeah.
Yeah, good evening. So myself, Rachel Andrea. So my question is that usually when it comes to domestic violence or any criminal act of anything of that sort, it's always on the woman. What about domestic violence against men? Nobody has ever spoken about that, or not many men come up with such cases. So what is your take on it? Have you dealt with any case regarding to domestic violence against men, or what is your say on it?
Thank you for asking it. First of all, that this particular question has been challenged in Supreme Court itself, stating that a particular act needs to be followed for men, but the court has decided that it is not the conducive environment, considering the status quo of India, that the men can come up with such legislation, because they may probably misuse it. And as you have rightly mentioned, that not a lot of opportunities are being provided to the men. But at the same point of time, we must not forget the fundamental remedies available under IPC. For example, recently I am being confronted with one of the issues, that the wife was having an affair with somebody, and the concerned person did not want the divorce. So he can of course proceed further with the fundamental IPC proceedings against the third person, of course, but not against the woman. And unfortunately, this must be adhered to and protect. I think DV Violence Act must be amended, and it should be gender neutral rather than specifically for women. So what can the court do? Court can ask, or court can amend it such a manner that the probably men need to prove it beyond reasonable doubt, whereas women can prove it on the basis of preponderance of possibilities. But yes, I also think that that this is a high time that where the court where the legislature must amend this particular act and include the men, and they may change the balance of probabilities to prove their cases.
It is very
Thank you
recent.
so much, sir.
It is very recent when Supreme Court has said that there is no need for domestic violence act for men as of now. Even last
Yes.
month only, it has been challenged in Supreme Court.
Yes, I agree. And even when this DV Act comes into picture in 2002, various litigations were filed not only in just High Court, in Supreme Court, but in various High Courts, demanding the same or the similar thing.
But Supreme Court said that today men are more powerful than women
Yes.
as compared to and there can be no domestic violence by the women on men. So they can't allow a specific legislation for this.
But I'm saying that
I completely agree, sir, but I wouldn't say that men are powerful than women. But yeah, I felt that because there are not many cases that are being reported, but a lot of things happening. I've been practicing in Madras High Court for almost 4 years now, and I've seen many men come up with such cases, and that's why I just wanted to check. I just wanted to know,
yes,
and you
probably
understand, right?
yes. It's the
Yeah.
only thing that you can ask for. It's the divorce, because in divorce you can come up with cruelty, and of course that you can file the defamation. So these two or three fundamental things which probably men can exercise, and they might get a sense of justice, and probably of course not the compensation, but relief I can what we can get for.
Yes, sir. Thank you so much, sir.
Thank you.
Thank you, Atin.
Thank you, thank you. So we are done with our question and answer round. If anyone else wants to ask the question, can ask. Else we'll end the session now.
Please, I can see a few questions, but it would be better if people can say yes, and then we can unmute them, because it's probably not feasible either for Ratan or for me to read all these questions. So if somebody actually wants to get the question being addressed, then probably he or she just can type it, or they can ask for the unmute.
Yes, Miss Kamia Manchanda, please.
Ms. Kamya, you may unmute yourself and can ask the question. Ms.
You have
Kamya?
to touch on the screen and then you can unmute yourself.
Or you can just type it here, we can read it. If you are unable to unmute it. Hello?
So no one else wants to ask any question? Ms. Kamia has typed her question. Shall I read it to you?
Yeah, please, because my system is quite fast. So
In domestic violence case, my husband is now ex parte, but still court always gives him another chance to file the reply. It's unnecessarily delaying my process. What should I do?
first of all, it depends upon the facts. Considering because there are various ways through which a person can prolong the matter. So if he is doing it smartly, then the limited course is available. But if you can come up with, if you can prove it, then what you can do, you can file an application before the same court, asking to take this issue 18 months are over. Okay. Then two things. First, you can file an application before the concerned court and addressing this issue. And at the same point, if suppose the application is not being addressed, then you can file the petition before the concerned High Court and ask the High Court to take this issue into consideration and direct the family court or the magistrate, whatever the case may be, to wrap up the entire proceedings as soon as possible. And once you file the case before High Court, in most of the scenarios, High Court do take cognizance of delaying tactics being followed by either of the parties. And once the directions are provided by the High Court, then in all possibilities, the family court or magistrate will follow these directions positively. So this is the step that you can come up with.
A writ petition has to be filed before the High Court of your concerned state.
Yes, before the concerned state, and if and probably for, one option can be can be considered before filing it, that either the concerned council can state it orally, or is it better to find some case laws where such thing has happened. But generally, it is the High Court which can give you the relief. And just last thing, probably it's on practical lines. I just settle one or a couple of related queries regarding that. It won't take so much time. It probably will take, I would say, 3 to 4 hearings. And if you belong to Delhi, since I basically practice in Delhi, Haryana, Rajasthan, so Delhi court generally wraps this things within a year or maximum 16 months or so. And at the same point of time, the your case in lower court can be proceeded. So you don't need to worry about that your main case is being stopped or will be stopped by the virtue of filing the case before High Court. It's not the case, but you may need to spend a few bucks for getting it done. So one and a half year or maximum 4 hearings that you can expect the court to take and decide your issue.
They filed a
should highlight in the Saket court. They filed a fraud case against the in Saket court. What's a fraud case? Of course,
so we can discuss this on personal, like
yes, that's exactly I was about to tell her that probably these questions anybody needs to read the petition and the on the facts of the case, and probably it's not the right for her to go into the peculiarities of the case, especially when I'm not confronted with the facts and the relevant documents. If you still want, of course, you can get in touch with us and secure the relief water. Is there any questions? I mean, are there any questions? I think people are probably
So we can end the session, sir.
Yeah, of course. Probably somebody has asked. Miss Safa has asked. Let me read it. Yeah. So basically, Ms. Safa is asking that the triple talaq is now being ruled out, and the non-billable offence where the concerned person can be arrested without warrant. And in such scenarios, how can the aggrieved party can ask for maintenance because the person will be arrested. Of course, this is the issue that was highlighted in the triple talaq bill by the opposite side, but the requisite amendment was not made, and this is one of the practical issues which will be there. But at the same point of time, what I believe, that despite being a non-bailable offense, and if the person will be arrested, he may be released within a few months, if not within few weeks. And once he gets released, of course, then you can ask for the maintenance. And the maintenance does not solely depend upon the husband. And if the husband is incapable, of course, the maintenance can be sought from his relative. Depends upon what case is going on, under what law it is there, and of course, it depends upon facts to facts. So it's not that the doors are entirely shut, but yes, for a certain point of time, for 1 month, for a couple of months, the issue is difficult to deal with.
So now we are coming at the end of the session. It was indeed a very insightful session, Lalit sir.
My pleasure.
And it's a pleasure having you on board. Now, Devshri, can you please stop the recording? If you have any questions from Lalit sir or us, you can anytime text us and we'll forward your questions to sir